Commerce and Energy will come to order. Okay, we have one housekeeping measure, House Bill 2491, request from the patron to be stricken from the docket. Okay, we have a motion and a second. Is everyone ready to vote? It's okay. Michael? Weber? You got it. Okay. The roll is closed. That is stricken 20-0. Okay, we're going to start with our subcommittee reports from last week. Delegate O'Quinn.
Thank you, Madam Chair. Of the report for Subcommittee Number 1, we met and heard extensive testimony on several bills, and I will give you the ones that we reported out. First bill is House Bill 1637 from Delegate Weber, which requires the State Corporation Commission to approve one additional application filed between January 1, 2023 and October 1, 2023 as a qualifying project to be constructed in whole or in part underground as a part of the existing pilot program for underground transmission lines. Madam Chair, the subcommittee recommended reporting this bill 8-0, and I so move.
Second.
Okay, we have a motion to report House Bill 1637 from the subcommittee. Is everyone ready to vote? Okay, the roll is closed. That passes 20-0. Delegate O'Quinn.
Thank you, Madam Chair. The second bill the subcommittee heard was House Bill 1669 from Delegate Marshall, which requires employers to pay employees younger than the age of 18 wages at a rate not less than the greater of $9 per hour or the federal minimum wage. The subcommittee recommended reporting this bill by a vote of 4-3, and I so move.
Okay. Delegate Ward, do you have a question?
No, I had a comment.
On this?
Yes.
Okay. Go ahead.
Okay, Madam Chair, I guess everyone knows that I'm in opposition to this bill, but it's just a couple of things I want to say. I wanted to thank
Is your mic
all
on?
the
Your microphone's on.
Okay. All right. Thank you, Madam Speaker. I know the direction of this bill from this committee. However, I wanted to make sure that we acknowledge all the young people who came to speak in support of this bill. And I just want to send a message to them that regardless of the outcome of this bill, there are many of us here in this General Assembly who understand your skills, your creativity, your talent, and your value of your young workers bring to this Commonwealth and to our economy. And we realize that the reason why some 16 and 17-year-olds are working, all of them varies. Some of you may be saving for college or to start a new business. Others of you are just working to help your family make ends meet. But either way this bill goes, it will, if it does not pass, it's going to make your goals a little bit harder. So for every person, all the young people that's looking at us, reached out to us and everything, I just want you to know to thank you and do not give up. Thank you, Madam Chair.
Delegate Marshall, do you need to respond?
Speak to the bill, please.
Go ahead.
So I would agree with everything except you're in the free enterprise system that the people who do a great job will get a higher pay. And so the purpose of this bill is to set a floor, not a ceiling. And so that if a young person goes into a job and does an outstanding job, they will get a pay raise, and that's American system.
Is everyone ready to vote?
Speak to the bill?
Delegate McNamara, are you on the subcommittee?
No.
You heard the bill?
No.
Okay, go ahead.
Speaking of bill, I did just want to say one thing that when you talk about under 18, when this original bill was passed 2 years ago, under 18 was exempted by, and I believe it was there was many votes on the other side of the aisle that voted this in, and under 18, under 20 hours a week was exempted completely from the statute. So I just want to make sure that was pointed out. Thank you.
Okay, we have a motion to report House Bill 1669. Indicate your vote on the electronic voting board. Okay, the roll is closed. The bill passes 10-8. Next, Delegate O'Quinn.
Thank you, Madam Chair. The third bill we heard was House Bill 1776, which was a bill that I have patroned, which makes permanent and amends certain provisions of the code related to the Business Park Electric Infrastructure Program conducted by VEDP. Madam Chair, the subcommittee recommended reporting this bill with a substitute 7-0, and I so move.
Second.
Okay. Did you say it as substitute?
Yes, Madam Chair.
Do you want to move the substitute?
Move substitute.
All right, all in favor of the substitute, say aye. Any opposed? Okay, Delegate O'Quinn. Motion?
I renew my motion to report.
Second.
Okay, we have a motion to report with substitute House Bill 1776. Is everyone ready to vote? Delegate Ward, did you want to vote? Okay, the roll is closed. That reports 21-0. Delegate O'Quinn.
Thank you, Madam Chair. The fourth bill we had was House Bill 1857 from Delegate Bennett Parker, which prohibits any person from using a website that displays trademarked or copyrighted information or text, images, etc., that is similar to that of an operator. Defined in the bill as a person that owns, operates, or controls a place of entertainment, or a rights holder defined in the bill as any person or entity that has the initial ownership rights to sell a ticket to an event without the consent of such operator or rights holder. Madam Chair, the subcommittee recommended reporting with a substitute 7-1, but there is a line amendment that we need to adopt.
Move substitute.
Okay, we have a motion on substitute. All in favor, say aye. Any opposed? Okay, do you want to report the amendment? I'm telling you.
Madam Chair, Delegate O'Quinn on line 224 of the substitute after graphics, insert website display.
And I believe that was from the State Corporation Commission? Who suggested that? I thought that's what I heard.
Madam Chair, I think that's correct.
Okay. Okay, did you move that? I'm
I
sorry.
would move that line amendment.
Okay, we have a motion on substitute, or the amendment to the substitute. All in favor, say aye. Any opposed?
Madam Chair, I would move that we report this bill with a substitute as amended.
Second.
Okay. We have a motion to report House Bill 1857 with substitute and amendments. Amendment? Or just substitute? You're going to, okay. Everyone ready to vote? Okay, Corey, do you want to vote? Okay, the roll is closed, 21-0, that reports. Next, Delegate O'Quinn.
Thank you, Madam Chair. The next bill we took up was House Bill 1895 from Delegate Phil Corn, which prohibits the inclusion of provisions in any employment contract that waive an employee, prospective employer, independent contractor's rights to disclose or discuss conduct that one employee reasonably believes under federal, state, or common law to be discrimination, including harassment, retaliation, a wage hour violation, sexual assault, fraud, or other conduct that is recognized as against a clear mandate of public policy. Madam Chair, I think you might have received a letter for re-referral on this bill.
Yes, Delegate O'Quinn, there was a lot of legal issues that came up after this bill was presented. The Attorney General's office weighed in on it as well, and it certainly makes sense to have another look at it. The Speaker sent a letter down to refer this bill for further consideration to the Committee on Courts of Justice, and I so move. Okay, we have a motion to refer House Bill 1895 to the Courts of Justice. All in favor say aye. Any opposed? Okay, that is referred. Okay, next, Delegate O'Quinn.
Thank you, Madam Chair. The sixth bill we took up was House Bill 1907 from Delegate Batten, which requires a consumer finance company or short-term loan provider to include as a part of every application a question regarding whether a potential borrower has been approached, including telephone or electronic means, by any person to send money in consideration of receiving money via government or lottery organization. Subcommittee recommended reporting this bill 7-0, and I so move.
Okay, we have a motion to report House Bill 1907. Is everyone ready to vote? That bill reports 20-1. Delegate O'Quinn.
Thank you, Madam Chair. The next bill we took up was House Bill 1921, also from Delegate Batten, and this bill prohibits any person from providing earned wage access services without first obtaining a license from the SEC. The bill defines earned wage access service. It also provides for qualifications for licensure, posting of a bond, annual fees, record-keeping, reporting, and disclosure requirements. It also authorizes the Commission to investigate and examine applicants and licensees, to suspend and revoke licenses, and to impose civil penalties. Madam Chair, the subcommittee recommended reporting with a substitute 5-2, but I would ask that we not adopt that substitute because there is another substitute to be considered. I would yield to Delegate Batten and Council. I'm not sure in which order.
Okay, so the motion,
I would
have
withhold the
to
motion for the moment.
we don't even have to take the motion up or not? Do we have to refuse it? Okay, so you said you have other amendments for this bill
Madam
before
Chair,
us?
I think what we want to do is not consider the substitute that was actually considered in sub. So the full committee should not adopt the substitute that reported.
They said we didn't have to do that.
Correct. And then we do need to adopt the substitute that is now being prepared for us to be able to consider it.
Okay, we have a motion on a substitute from the full committee here. Is everyone, you're making a motion for that. Do we have a second?
Second.
All in favor of the substitute, say aye. Any opposed? Okay, Delegate Batten, tell us about your substitute.
Thank you, Madam Chair. After this bill reported out of subcommittee, we heard from a number of stakeholders. They are all engaged in the same industry, and that includes members like Discover and MasterCard, and they are all using a model that would be regulated in my bill. So I have a substitute today that addresses a number of the concerns that were brought up by the stakeholders. I just want to note that several of the concerns that were brought up by those stakeholders in the industry also would have likely created concern with regulator, the Bureau of Financial Institutions, and they were related to items that were worked out several weeks in advance of session. So just an example, some of the stakeholders were concerned with BFI setting fees on these entities, but that is actually standard practice in Virginia and allows the agency to cover cost of regulating. Some others wanted not to have to hold this license if they already hold another type of license with the BFI, and that would allow them, which would allow them to offer earned wage access unregulated. So these are not some of the recommendations that we included. But it does include the primary requests of the companies, that there are different business models and methods by which these companies are providing early access to wages. And so we did try to address as many of those as we could with this substitute. I know that there were some other stakeholders that raised concerns with the bill, and the substitute also addresses their concerns, ensuring that we're not impacting employers who provide a paycheck advance directly to their employers. Definitely does not allow for a cycle of debt or increased payments, and it removes any statement, the substitute removes any statement as to whether or not this activity is providing credit. I just note that consumer advocates in other states have been supportive of this industry because it provides a free option to consumers. And I would hope that it would be the pleasure of this committee to support an option, to support a substitute that continues with this free option that allows for more consumer protections.
Delegate Sullivan, you have a question?
Yes, actually, it's a question of you, Madam Chair.
Yes.
My question, Madam Chair, is given that the bill is fairly different and the patron has indicated she's made some changes in response to stakeholder comments, whether you intend to take any further testimony, hopefully briefly, from Bureau of Insurance, for instance, or any other stakeholder who might want to weigh in on the new information.
Madam Chair, I would say that there are representatives here from the State Corporation Commission as well as some of the industry stakeholders.
Okay. Because the substitute has got quite a few changes in it, if the patron is okay with that, we will take testimony on this.
Thank you, Madam Chair.
Okay. Do you want the State Corporation Commission to come forward, or do you want me to just hear from the people that are in support of the bill?
I think if we could maybe hear from the people who are in support of the bill with the new language, and then perhaps if they could call upon State Corporation Commission and some of the other regulatory folks, that would be great.
Okay. Please come forward.
Madam Chair, members of the committee, Nicole Brenner with Reed Smith on behalf of EARNIN. EARNIN is one of several providers of earned wage access services. We do so in partnership with employers and directly to consumers, which are two of the business models contemplated in the legislation. We appreciate the delegate bringing this legislation and the Bureau of Financial Institutions and the AG's office for working with us on necessary changes to provide significant consumer protections and sufficient regulation of this industry. I did speak on this bill in subcommittee, but since not everyone was there, our business model includes the option of expedited delivery of funds and a tip, similar to tipping your DoorDash driver. And I'd like to point out a couple of the provisions in the bill that are consumer protections. There's an annual report on these transactions and payments. The bill is not effective for a year, so you would get information on all of the transactions that are happening and any payments that occur. This will provide information on the industry and inform any future regulation. There's also a number of prohibited practices and consumer protections. Providers of earned wage access cannot require a credit score, report to credit, they cannot send consumers to debt collection, bring a civil action, or mandate any fees and charges. Not only would we be subject to licensing and regulation, penalties by BFI, they can be referred to the Attorney General's office and subject to violations of the Consumer Protection Act. None of these currently would exist in Virginia absent Delegate Batten's legislation. Finally, I would remind the subcommittee that this provides an entirely free option to consumers with robust consumer protections. We would ask for your support.
Please come forward.
Madam Chair and member of the committee, thank you very much. My name is Clark Worthen. I'm an Associate General Counsel at Daily Pay, which is the largest provider of earned wage access in the country, operating in all 50 states and serving well over 1 million customers to provide our service. I'm actually here today to speak in opposition of the bill as it is currently drafted. We welcome very much legislation to regulate the industry and are supportive of that if we get it right. It would be the first earned wage access law in the country, but there are, as was previously noted, a number of players in this nascent industry with a number of very different models of how to provide this service that we do think and all agree is very important and essential to be able to provide folks who need access to their funds before their regularly scheduled payday. I would point out there are really three main areas that we continue to work with constructively with our partners in the industry who do have different models, but they do hit on very important topics like licensing exemptions. And we've spoken with the SEC and will continue to do so constructively. Also, as was mentioned, the fee model and how revenue is earned by these companies, be it a tip model or a flat fee model. Again, important things to hone in on the bill and, again, just make sure that we get right. Finally, consumer protections are something that Daily Pay takes very seriously, and the industry needs to take seriously, and again, just needs to get right and have a thoughtful and measured approach to make sure that we're covering all our bases. The different models that can provide the service candidly do have different levels of risk to the end consumer, and it's something that, again, we want to make sure is fully covered off so that the folks in the Commonwealth, and again, this would be a first in the nation law if it were passed, we want to make sure that end consumers really are protected. So thank you very much. But we
Thank
are
you.
opposed as it is currently drafted.
Yes, Dagobert.
Could I ask this gentleman?
Yes.
Thank you, Madam Chair. You used the phrase different levels of risk. Could you expand on that a little bit?
Sure, I'll probably jump to the easiest example. There are, again, different models of how to do it. Daily Pay, again, the largest provider, is an employer-integrated model. So to provide the service that allows you to take a portion of your earned pay, shifts you've already worked, but get access to that money before payday, the way we do it is we partner with your employer, and we are integrated in their payroll system. We're integrated in their timekeeping software. So we actually know, because we've gotten it directly from your employer, we know if you've worked that shift or not. And in fact, our software at the end of your shift quite quickly will show you've got an available balance you can now draw down because you've just finished that. And because of that, we also work, we process through the direct deposit system. We get, there's never a draw from your bank account from us because we're already integrated with the payroll system and integrated with your employer. So some other models, and again, it's an industry that we are supportive of, and we want each model to be able to work. But there are certain other models where you could actually debit from the end user's bank account, and that does present risk. So if something goes wrong in the system and there happens to be not enough to cover the earned wage access provider pulling out from the end user's account what that early advance was, if that money's not there, then you've got a user who's going to be in an overdraft situation, which is, again, exactly what the service is meant to avoid.
Madam Chair, if I could just follow up.
Yes, go ahead.
So the legislation that we have before us today, you're familiar with this amended version, the substitute that's before us?
Yes, there are a number of folks. I know all of these players who are working at it right now.
So does it have the requisite care protection for folks who would be in the second category you just mentioned, where it comes out of their own bank account?
I think our position is that it does not have as fulsome a protection as we would like, and that it needs further work from the industry to make sure that folks are protected.
Thank you. Thank you, Madam Chair.
Delegate Sullivan, is the question for this gentleman?
Yes, Madam Chair, it is.
Go ahead.
So, thank you for your testimony, sir.
Thank you for the time.
Our choice today, at least today, is leaving it. Let me ask the question this way: am I right that the industry in Virginia is currently completely unregulated? Is that right?
That is correct. There's not an earned wage access law.
But you're active in Virginia.
We're active in all 50 states. Yes, sir.
And other. I'm sorry, Madam Chair.
Go ahead.
And other. I don't know if they're your competitors, but other people in the industry are also active in Virginia.
That's correct. That's correct.
One last question, Madam Chair.
Go ahead.
Just so I understand your testimony, so you're suggesting that no regulation is better than this regulation?
We would prefer to have the regulation done right and get it right the first time, and have feedback from a number of industry players that have attacked this problem from different ways. Problem's not the right word, but who provide this service with different models. We think if we're going to put legislation on the books, and if Virginia is going to lead the nation in doing so, it should be a bill that is thoughtfully and well done with again feedback from players who do it differently.
Thank you, Madam Chair. Thank you, sir.
Okay, next, please. Did you, by the way, did you speak at the other subcommittee?
I did not.
Okay.
Jay Spear with the Virginia Poverty Law Center, and we are opposed to the bill. This bill is not a solution to a problem. It's not been requested by consumer advocates, worker advocates, or consumers themselves. No one is trying to eliminate this industry. There's no great urgency There's no fire here. There's no need to regulate these folks. Now, I've heard that they are telling folks that we are already operating in Virginia, you need to regulate us. That is word for word what the payday lenders told us over 20 years ago, and then we spent over 20 years with legislation on payday lending every single year until finally in 2020, we passed the Fairness in Lending Act to take care, and we now have a marketplace where there are affordable loans for people. The problem with this product is that it is exact opposite of what we outlined in the Fairness in Lending Act, which is affordable loans that you pay back in installments. This is just like a payday loan, you pay the whole thing back at once. They take it out of your bank account. Now, the company that's pushing this, Earnin, was sued and paid $12 million because they were overdrawing so many folks' bank accounts. And I would suggest exactly what the previous speaker said. There's a lot of different companies here. We need to consider everybody's input and whether we even need legislation at all. But this is not something we should do on the fly and make all these changes. I haven't even seen the substitute, and I'm sure they're going to make more changes even later. We just need to take our time with this. We can do a study, talk about this, what needs to be done, and consider it next year. Thank you.
Delegate Batten.
Madam Speaker, I would just like to note that there are a number of prohibited practices on lines 278 through lines 310 that certainly provide significant consumer protections. There's nothing right now in our code that allows for those protections. Additionally, this is a product that is already being widely used in the Commonwealth, and as I said, there's nothing right now providing for consumers protections. I also know that, as we mentioned, we worked really hard to address the stakeholders' concerns, and the concerns that are not addressed in this substitute are the ones that were flagged by SEC and BFI as practices that, to my understanding, they would not be in support of. So I don't know if there's anyone here who wants to speak to that, or if the original speaker wants to address any of that, but I do think that this is an industry that is not akin to payday lending. I do not believe that that is an accurate representation of it. If you read the consumer protections, it does not allow for clawbacks. It does not allow for interest to be charged, and a number of the other associations that we would normally make with payday lending. It is a way for consumers to access the wages that they have already earned without subjecting them to predatory measures.
Last question, Delegate Corey.
Thank you, Madam Chair. This is a question for Delegate Batten.
Go ahead.
Thank you. It's my understanding that this was turned into a study in the Senate, and Delegate Batten, I wonder if you are supportive of that. I believe that is what the Poverty Law Center is encouraging, and if you're comfortable, I'd like to hear your opinion.
Madam Speaker, Delegate, I have not had a chance to fully review the language that came out of the Senate. I'm not sure if any of the stakeholders here want to speak to that. I'd be happy to defer to them.
Thank you. Madam Chair, Nicole Brenner on behalf of Earnin. The Senate hasn't had a hearing on this bill yet. I met with Poverty Law last week. My client spoke with Poverty Law last week. I'm happy to continue conversations during session or afterwards. I would note that Delegate Batten's bill doesn't go into effect for a year, so those conversations can happen either way. Happy to have them. Consumer advocates are extremely supportive of this option in other states. In other states, they put it on their website and say, use this option, don't do payday. This is much better. I would note that this is a free option. In 2020, you approved monthly maintenance fees, finance charges. None of those are permitted in this bill.
Delegate O'Quinn.
Thank you, Madam Chair. I would speak to the bill, I guess. The subcommittee recommended reporting the original bill with the original substitute 5.2. I think this is a substitute that is a little more comprehensive in how it has dealt with and listened to the various stakeholders. I also feel like this is one of those bills that, unfortunately, Delegate Batten, you're probably going to get to work on for a while longer. So we're most likely going to get at least one or two more bites at the apple on this. So I would move that we report with substitute.
Second.
Okay, we have a motion to report House Bill 1921 with a substitute. Is everyone ready to vote? Okay, the roll is closed. That passes 11-9. Delegate O'Quinn.
Thank you, Madam Chair. The eighth bill we took up was House Bill 1974 from Delegate Rome. This bill provides that construction and reconstruction of any underground electrical transmission lines of at least 69 kV along a highway right-of-way under the jurisdiction of VDOT in Planning District 8, where data center proposal is under construction, is an area located within a half mile of a national battlefield park and within 1 mile of a state forest, is in the public interest. Madam Chair, the subcommittee initially recommended reporting this bill. I was not on the prevailing side of that, so I would not make that motion myself.
Yeah, Mr. Delegate O'Quinn. This particular bill, I think we looked at one similar to this in finance, and I don't know, this is probably going to get the record for the most amount of emails that we have received in one session regarding a bill. And there's a lot of issues surrounding this bill. A lot of people are very concerned about it, and I would like to make a substitute motion to lay this bill on the table.
Oh, it's second.
Okay, that's non-debatable. We have a motion to lay House Bill 1974 on the table. Is everyone ready to vote? All right, that passes 11-9. Bill's laid on the table. Delegate O'Quinn.
Thank you, Madam Chair. The ninth bill we took up was House Bill 2130 from Delegate Wilt. This requires electric utilities to petition State Corporation Commission for relief from requirements of certain provisions of code that mandate the retirement of electric generating units that are coal-fired or emit carbon as a byproduct of combusting fuel to generate electricity if such requirements would threaten the reliability or security of electric service to customers. The subcommittee recommended reporting with a substitute, and I would move that substitute.
Okay, we have a motion on substitute. Is everyone approval of the substitute? Say aye.
Aye.
Any opposed? Delegate O'Quinn.
Madam Chair, then the subcommittee recommended reporting with that substitute 5-2, and I so move.
Okay, we have a motion to report House Bill 2130 substitute. Is everyone ready to vote? The roll, Delegate Weber, do you want to vote on your own? Oh, no, it's Wiltz. Okay, the roll is closed. That passes 12-9. Delegate O'Quinn.
Madam Chair, the final bill we took up was House Bill 2179 from Delegate Moorfield, which authorizes the use of commercial delivery services with signed and dated acknowledgement of delivery by the Commissioner of Labor and Industry when providing notice to an employer of any proposed penalty for a violation of safety or health provision or the employer's failure to abate a violation of a safety or health provision. Under current law, the Commissioner is authorized to provide such required notices only through certified mail or personal service. Subcommittee recommended reporting 7-0, and I so move.
Second.
Okay, we have a motion to report House Bill 2179. Is everyone ready to vote? The roll is closed. That passes 21-0. Does that complete your report?
Yes, Madam Chair.
Thank you very much for all your work. Delegate Webert, Subcommittee 2.
Yes, Madam Chair. After a pretty long and thorough subcommittee, Subcommittee number 2 acted favorably on a few pieces of legislation. The first up is Delegate Bulova 1631, and it allows dispatchers, as defined in the bill, to claim workmen's compensation benefits relating to post-traumatic stress disorder under the Virginia Workmen's Compensation Act. Currently, only law enforcement officers and firefighters may claim such benefits. The subcommittee recommended reporting and referring to appropriations 8-1, and I so move.
Okay, we have a motion to report House Bill 6.
Then we need a motion.
I would move to report and refer to appropriations.
Okay, we have a motion to report House Bill 1631 and refer to
Thanks.
appropriations. All right, everyone ready to vote? Okay, that report, I refer 21-0. Doug Weber.
Next up, Madam Chair, is House Bill 1640 from Delegate Kilgore that dealt with Medicare supplement policies for certain individuals under age 65, and it requires each insurer issuing a Medicare supplement policy or certificate in the Commonwealth to offer opportunity of enrolling in at least one of its issued Medicare supplement policies or certificates to any individual under age 65 who resides in the Commonwealth, is enrolled in Medicaid Part A and B, and is eligible for Medicare by reason of disability, including individuals with end-stage renal disease. That's where the bill takes effect. The bill also prohibits an insurer from charging individuals who become eligible for Medicare by reason of disability and who are under 65 of age premium rates for any Medicare supplement plan or certificate offered by the insurer that exceeds the premium rates charged for any plan to individuals who are 65 age of older. The subcommittee recommended reporting with amendments, so I'd like to move those amendments.
Okay, we have motion only amendments. Everyone in favor say aye. Aye. Any opposed? Okay.
And the subcommittee recommended reporting as amended 5-2, and I so move. I did vote again. Did I vote?
Delegate Kilgore moves that we report House Bill 1640 with amendments. Is everyone ready to vote? All right, the roll is closed. That reports 20-0. Doug Weber.
All right, I did not vote against this one. HB 1924 from Delegate Hope provides that individuals with disabilities that are paid at a sub-minimum wage pursuant to the Federal Labor and Standards Act are employees for the purposes of the Virginia Minimum Wage Act. The bill requires every employer of such employees to pay such employee wages at a rate not less than from July 1 to 2023 to July 24, $9.50 an hour, then $10.50, then $11.50, and then the bill requires from July 1, 2026, every employer of such employees pay such employees at a rate equivalent to all the employees covered by the Virginia Minimum Wage Act. The subcommittee recommended reporting 8-1, and I so move.
Okay, we have a motion to report House Bill 1924. Everyone ready to vote? Okay, the roll is closed. That report's 21-0. Delegate Weber.
Next up is HB 2262 from Delegate Hodges that dealt with health insurance provider credentialing and processing of new applications. Requires a health insurance carrier that credentials the physicians, mental health professionals, or other providers in its network to establish reasonable protocols and procedures for processing of new provider credentialing applications. The bill requires such protocols and procedures to require the carrier to approve or deny new provider credentialing applications within 60 days of receiving a completed application, and to provide notice to the new provider applicant that the provider's application is received and complete. The bill also requires payment no later than 30 days after the carrier approves the new provider credentialing application for services that are rendered from the date the new provider applicant's completed credentialing application is provided to the carrier for consideration. I need to move the substitute first. So I move the substitute.
Okay, we have a motion on substitute. All in favor, say aye. Any opposed? Okay.
And what
Delegate Weber.
the substitute made changes to the requirements under subsection B and requires VDH to promulgate regulations to be effective within 280 days of the enactment of the bill. Subcommittee recommended reporting with substitute 8-0, and I so move.
Okay, we have a motion to report 2262 with substitute. Everyone indicate your vote on the electronic voting board. Roll is closed. The bill reports 21-0. Doug Weber.
Next up is HB 2418 from Delegate Wampler. First, I need to move an amendment, and it's a simple amendment that replaces the word pool with association.
Second.
Okay, we have a motion on the amendment. All in favor, say aye. Any opposed? Doug Weber.
As amended, this bill provides that subject to approval of the State Corporation Commission, 2 or more workmen's compensation group self-insurance associations may merge if the resulting group self-insurance pool assumes in full all obligations of the merged group self-insurance association. Subcommittee recommended reporting as amended 8-0, and I so move.
Okay, we have a motion to report 2418 with amendments. Everyone ready to vote? The roll is closed. The bill reports 21-0. Doug Weber.
Thank you, Madam Chair. Madam Chair, next up is HB 2422 by Delegate Batten. There is a substitute that I need to move first, so I move the substitute.
Okay, we have a motion on substitute. All in favor, say aye. Any opposed? Doug Weber.
Thank you. HB 2422 clarifies that the definition of home solicitation sale includes a solicitation of the sale or lease of goods and services in which the seller engages in a solicitation without prior invitation, appointment, or consent. The bill excludes from the definition of home solicitation sale I, consumer sales made by an entity regulated by the Bureau of Insurance, and sales made entirely by telephonic or electronic means at the initiation of the buyer without any other contact between buyer and the seller. The bill also prohibits a buyer from canceling a home solicitation sale if the seller in good faith begins performance of the contract at the buyer's request. Subcommittee recommended reporting with substitute 9-0, and I so move.
Okay, we have a motion to report House Bill 2042 as amended, or substitute. Everyone ready to vote? The roll is closed. That passes 21-0.
That completes my report, Madam Chair.
Thank you, Delegate Weppert. Subcommittee 3, Delegate Head.
I think it's
Marshall,
Delegate
I'm sorry.
That's okay.
Wrong one.
So House Bill 1643, I think we have a substitute, so I'd like to move the substitute.
Second.
We have a motion on substitute. All in favor, say aye.
Aye.
Any opposed?
So House Bill 1643 by Delegate Kilgore provides that for the purpose of the Virginia Electric Utility Regulation Act, Renewable energy includes coal mine methane, defined in the bill as methane contained within a worked-out area of an underground coal mine that will eventually escape to the surface. And I move the substitute. It passed sub on an 8-0 vote, and I so move.
Madam,
Delegate Kilgore.
I would say that we're not saying that coal bed methane is a renewable energy. What we did in the substitute, we set up a working group with the Department of Energy to continue working on some of the issues involving the cleanup of coal mine methane, and it had support from all groups. So that's what we did in the substitute. Thank you.
Okay. Delegate Marshall, you had a motion to report with a substitute?
I did.
Okay. Is everyone ready to vote?
We did, I think.
Okay, that bill reports 20-1. Delegate Marshall.
Thank you, Madam Chair. House Bill 1752, that's a substitute, and I move the substitute.
We have a motion on substitute. All in favor of the substitute, say aye. Any opposed? Delegate Marshall.
We had a lot of testimony on this bill, and what this bill does is provides that a broadband service provider in the construction of its works may cross the works of a railroad company if the crossing does not interfere with the works and operations of the railroad company and is designed to prevent damage to the works of the railroad and ensure safety of its passengers. The bill requires the broadband service provider give notice to the railroad company of its desired crossing. The bill passed 7-1, and I move the substitute bill. Second.
Okay, we have a motion on substitute. All in favor, say aye. Any opposed? All right, Delegate Marshall.
I move to report.
Okay, we have a motion to report the substitute for House Bill 1752. Is everyone ready to vote? All right, that bill reports 21-0. Delegate Marshall.
Next bill is House Bill 2197, which is the chair's bill, and we have a substitute on that bill, and I move the substitute.
We have a motion on substitute. All in favor, say aye. Any opposed? No. So this bill is actually Delegate Kilgore is also chief co-patron of this bill as well. So Delegate Marshall, go ahead.
All right, provides that for the purpose of the Virginia Electric Utility Regulation Act, renewable energy includes energy from advanced nuclear technology. The bill provides electric generating resources that generate electricity energy derived from advanced nuclear technology located in the Commonwealth or physically located within the PJM region. I move the substitute.
We already did that.
I move the bill.
Okay, we have a motion to report 2197 with substitute. Is everyone ready to vote? Okay, that good bill passes 12-9. Okay, Delegate Marshall.
We have another good bill. House Bill 2311 is a wrong bill. House Bill 2305. And so that bill is a renewable energy portfolio standard sources. Provides that any construction of acquisition of sub-zero carbon electricity generating capacity or energy storage resources by a Phase 1 or Phase 2 utility for the purpose of meeting the Commonwealth's renewable energy portfolio standards shall be subject to the competitive procurement and solicitation in demonstrated economic development benefits to the Commonwealth. I move the House Bill 2305.
Okay, we have a motion to report House Bill 2305. Is everyone ready to vote? Okay, the roll is closed. That passes 12-9. Doug and Marshall.
And I think that wraps me up for the day.
Okay, great. I don't know about the day, but for now. Sub 4, Delegate Head.
Thank you, Madam Chair. We had two bills to report. Had House Bill 1797 from Delegate Freitas on renewable energy and offshore wind development. This provides that for the life of offshore wind facilities constructed by a Phase 2 utility, customers shall be held harmless for any shortfall in energy production below an annual net capacity factor of 42%, as measured on a 3-year rolling average and as determined by the State Corporation Commission. Subcommittee recommended reporting on a vote of 5-3, and I would so move.
Okay, we have a motion to report House Bill 1797. Is everyone ready to vote? Okay, the roll is closed. That passes 12-9. Delegate Head.
Thank you, Madam Chair. We also had House Bill 1875 from Delegate Helmer. This bill requires the State Corporation Commission to establish by regulation exemptions to termination of service by a public utility that provides electric, gas, or water and wastewater services for certain residential customers. Bill requires such regulations to require a public utility to delay termination of service for any residential customer who hasn't filed a serious medical condition form with the public utility for 15 calendar days upon oral or written notification from the residential customer that such a customer or family member residing with the customer has a serious medical condition, and that for such customer the utility shall delay the disconnection for at least 60 calendar days upon receiving medical condition form during that 15-day period, and also who has filed a serious medical condition form within the public utility for at least 60 days beyond the expiration of any required termination, or who certifies to the utility that the customer's household includes primary residents who are not younger than 65 years of age, not older than 12 months of age, or who have a disability for a minimum of 60 calendar days beyond the expiration of the termination notice. Requires that for any residential customer who's experiencing financial hardship and whose serious medical condition will last beyond the 60 calendar day period described in Clause 2, the utility shall work to establish a payment plan to make all due effort to avoid serious termination. Several other features in that. At any rate, the subcommittee recommended reporting with a substitute and a vote of 5-2, and I would so move.
We have a motion on substitute. All in favor of the substitute, say aye. Any opposed?
Substitute motion.
Delegate Marshall.
I move that we table the bill.
We have a motion to lay House Bill 1875 on the table. That is non-debatable. Is everyone ready to vote? Okay, the roll is closed, 11-9. Okay, Delegate Head.
Madam Chair, that completes my report.
Okay. All right, we're going to move on to our full committee. I believe we have 3 bills, is that correct? Let me get myself back together again. And then we will move on to sub 2. So we have Delegate Kilgore.
Madam Speaker, Madam Chairwoman, I think we have a substitute on House Bill 1784.
There's a little confusion over this bill because we kept taking it by and then,
Just
you needed
trying
more
to-
time, and then I see it actually came out of subcommittee. So, but you have a substitute, so we're going to start all over again. How's that?
Okay,
All right?
that's fine.
So we have a motion on substitute? Okay, all in favor of the substitute, say aye.
Aye.
Any opposed? Okay, Delegate Kilgore, tell us about the substitute.
You might want to, can you tell us what we did with the substitute? I think we included in the substitute some amendments, technical amendments by the AG's office, but also some other amendments. Is that correct?
That's correct, Madam Chair. Delegate Kilgore, the substitute does not contain the first part of the bill about exempting this new decentralized autonomous organization from the securities requirements, securities registration requirements. A couple other aspects of the new chapter are consolidated, and the substitute contains technical amendments. Thank you.
Thank you. I thought that's what we did. So we did take, there was some concern about it being exempted from the Securities Act. So we took that out, and therefore if you are, then you'd go back, if it's a security, you'd go back to case law. There's Howey versus Supreme Court, in U.S. Supreme Court ruled that the investment contract for the purposes of Security Acts would mean a contract, transaction, or scheme whereby a person invests his money in a common enterprise and expects to profit from that. So that, if you're doing that with this Bitcoin, then you would fall in the Securities Act. But as we heard in the subcommittee, there are other uses for this type of contract. For example, people who are wanting to, we heard one guy come forward where they bought all the property over in Dungannon in Scott County, Virginia, where they came together to buy property as a group, and they set up their little group and didn't expect to make a profit from it, but they were expecting to protect the property from development and put a conservation easement. So there, that would be a better, that's one way of using it. And then, of course, if you want to make money, you'd be under the Securities Act. But I think we have worked on this, worked with the AGs on this to try to get it more palatable to folks. So that's the bill now.
Does anybody have any real technical questions they want to ask Delegate Kilgore so he can explain? Do you carry digital tokens in your pocket or anything?
No, you don't carry those in your pocket. All I got in my pocket, Madam Chairwoman, is three quarters. But I would say that digital tokens are, it's a computer programming. It's a Bitcoin, and they set all this up, and they set programs up, very complex programs to mine this, and there's a big opportunity here for Virginia. Wyoming has really led the country in Bitcoin mining and this type of activity, but Virginia could actually be the number one leader because of where we are, where we're located on the East Coast and the fact that we're where the internet is located. So we could really, really do well in this area.
I'm going to tell the speaker we need you on science and technology.
I spent 4 years on there. I finally got off of it.
Delegate Mullen, you have a question?
Madam Chair, I was just wondering if there was anybody from the Corporation Commission, since this is
I've
a
met
pretty
with them.
big
I've
change
met with
from
them
what we
also.
were. Yeah, I was just wanting to hear from them since the substitute might.
Yes.
Madam Chair, members of the committee, my name is Bernard Logan. I am the clerk at the State Corporation Commission. We have worked with the delegate with the technical amendments, basically the language as it relates to the type of business entity, all right, making it fit within the LLC Act. So we submitted the language to align, that way making the implementation more aligned with the act as it's written today, and as well as an enactment clause.
Okay. Does that answer your question, Delegate Mullen?
Yes, Madam Chair. Madam Chair, were there other people who had not given testimony in the?
Well, we'll get to that. You had a question for him, so that's where I was going.
He answered my question.
For right now.
Thank you.
Delegate Ware has a question too.
Thank you, Madam Chair. And I heard the gentleman say you're the clerk for the commission.
Yes.
Will this be regulated under the Bureau of Financial Institutions?
Well, I have my colleague from the Securities Division here with me, and I'm going to throw out a lifeline and have him come up and address that issue. He's ready for that.
Good afternoon, Madam Chair
Good
and members of the
afternoon.
committee. My name is Doug Joyce. I'm the Director of the Securities and Retail Franchising Division. And we would be responsible for regulating, and as Delegate said, our first order of business is to make sure we apply the Howey test to make sure that any security filing exemption met or did not meet that Howey test.
Madam Chair,
Yes.
could I follow up on a
Delaware,
couple of
go ahead.
questions? I've read the elements of the bill, and I still am finding myself somewhat struggling with this language. Could you define a digital token exemption in plain English?
I may have somebody else here. Somebody else might be better equipped to do that than I, actually. As we were looking at the original
It's pretty
law,
bad.
it talked about a consumptive token. Now, when I think of a consumptive token, what I would think of is, in very English terms, I would think of access to goods and services. So you're buying access to, let's say, a Costco membership. So you would buy access to that, allow membership to Costco, go in and buy their goods and services. Relative to the digital world, I understood to be you buy access to the blockchain technology to be able to use that blockchain technology for the purpose that it's meant.
Delaware.
Same thing in regard to decentralized autonomous organizations. Could you, again, put that in plain English?
Well, what it is, it's a organization that is run using a smart contracts on a blockchain rather than being controlled by a central authority or group of people. So what it does, you put all this into the computer, it runs the program, makes the contract that your group has already decided to do so that you don't have all these folks running around. They just go out and buy the land or buy a product or something together that you've all agreed on. It can be used to create decentralized financial services such as lending, borrowing platforms, but also, it can use, you get into Bitcoin and all kinds of things. But it's a great opportunity. There's over 10,000 DAOs registered with $5 billion worth across the United States. But the leading ones that are really have been innovative in the DAO legislation is Wyoming, Tennessee, and Vermont, and now Texas is looking to really get into it.
So I guess, Madam Chair,
Delaware.
I recognize that opportunity, and I'm all for Virginia being at the forefront again. I guess, having read the news stories recently about some of this technology and its uses and its tokens, I'm more than a little bit concerned about some of the financial losses that the people have experienced with this kind of technology.
Well, if it's going to be securities like that would have been, it would have been scrutinized heavily by our SEC. Most of what we're going to be using the DAOs for are not going to be in securities area. It's going to be used for other things like buying conservation property, things of that nature. But if it's going to be security and it's going to be something like we're talking about in that particular circumstance, these individuals are going to be looking at that pretty heavily.
Thank you, Madam Chair. Thank you.
Delegate Sullivan, do you have a question for these folks up there, or do I need to hear from folks in the audience?
I had a question for the patron, ma'am.
Okay, go ahead.
Gosh.
Delegate Kilgore.
I'm going to have to phone a friend here in a minute.
Well, that'd be fine with me. I think this is what Delegate Ware was referring to. I mean, I can tell you about the only thing I know about this goes by the initials FTX, right? And
Yes,
just
exactly.
It's a really, to me at least, complicated and somewhat scary area. I am wondering whether something this complicated, and obviously I haven't been at the table, so maybe you're going to tell me that there's been, that every nook and cranny has been thought through with every member of the quote unquote stakeholders. But I see that that as drafted with your enactment clause, it's not even going to take effect for a couple of years.
Right.
And my question to you is, does it not make sense to look at this bill, get everyone in one room, do it, study it for a year, and then you can come back next session, and then we can put an enactment on clause that's either immediate, or at that point, we still got a year left.
Well,
Are you, I guess my question to you, Mr. Delegate Kilgore, is, are you concerned that we're moving too quickly?
Well, I'm not concerned because we do have that 2 year. It's going to take a while before the clerk's office at the State Corporation Commission can come up with the technology to make sure that, under the LLC and all that, that we have a way that we can form these corporations. And in the meantime, I can tell you, we're going to be back here next year working on this just to make it a better piece of legislation, to make changes. And I'm willing to make changes as have you seen through this process. I'm willing to make changes as we go along. I just think we have an opportunity, and we need to move this year so that they can, down at the State Corporation Commission, move forward with getting that technology in place. Then if we decide at some point in time to pull the plug, we pull the plug. But that's what I would say, Delegate Sullivan.
Thank you, Madam Chair. Thank you, Delegate Kilgore.
Okay, is there anyone here that wants to speak in favor of this bill? Anyone in opposition?
Take that out. Right. No, go ahead. I took the securities out.
Madam Chair, members of the committee, Eric Link, appearing on behalf of the Virginia Bar Association. The association's business law section has some significant concerns about the sweeping nature of the legislation, especially given that it would purport to govern an extremely unsettled area of law and an extraordinarily volatile sector of the digital economy. We do appreciate Delegate Kilgore talking to us, and we appreciate the fact that the substitute does, I believe, address some of their concerns. However, like any good bunch of lawyers, they have other concerns. The two of them I just want to share with, not enough clients is the other. The first, real quickly, the first is the identification of owners is apparently anonymous. If the management is vested in its members or a smart contract, who has the authority or responsibility to make filings with the SEC, the IRS, or the SEC? I can see I'm putting you all to sleep, but these are some concerns that they have. The other one is the LLC may not be the best vehicle in terms of choice of entity for DAOs. The concerns that they expressed were that typically the way that the DAOs are written, they require a very, very low voting participation, but even then, a lot of them don't have the participation levels met for action on the behalf of the DAO. So how do you take any action if you want to change the DAO? So they become these dead entities, so to speak. I'd be happy to answer any questions to my limited ability that the committee might have.
Delegate Sullivan, do you have a question, or are you still up on the board here?
Well, I had meant to turn that off, but in fact, I do have a question of the witness.
Go ahead.
I mean, my question to the lawyers, my friends at the VBA, is do you oppose the bill, or do you think it should be, we should study it more, wait on it more?
As usual, a compelling question. Without having seen the substitute, which I think, based on his description, does address some of their concerns, I think, unfortunately, we still would oppose it.
Okay, Delegate Corey. Oh, he said you had a question. No, okay.
Okay.
Okay, Delegate Kilgore, final word.
I just say that, I'm willing to, I think we should move this bill forward. I'm willing to work through the process, work through the Senate. If the Senate puts if we, we'll work through the Senate and try to figure out what the best way to move is. I think addressing the concerns from the VBA about securities. I still think this is an opportunity for Virginia to become a leader in this area, and it could bring billions of dollars and data mines all across the Commonwealth. And I just think it's an opportunity too good to pass up, and I would ask that you pass the bill.
Delegate Head.
I have a motion.
Go ahead.
Would move to report.
Second.
Substitute, right? Do we have a second? Okay. Is everyone ready to vote on House Bill 1784 with a substitute?
I vote yes, too.
Margaret, you having a problem too? Excuse me? All right, hold on. It seems to be coming in now. It's working on my side. So we've got, except for Delegate Goditis. What's your vote? Okay. I've got 13-8, right? Okay, the roll is closed. The bill passes 13-8. Delegate Kilgore, do you have another?
Oh, I have another bill.
I forgot.
This is House Bill 2487. And just briefly, this addresses power disparities between soft drink companies and Virginia's independent soft drink bottlers. Most of our independent soft drink bottlers, they spend many years.
2486?
2486.
Okay.
Spend many years and generations building a prosperous manufacturing business. And currently, when a soft drink bottler seeks to transfer ownership of the business to a family member or sell the business outright to another bottler, a soft drink company can block the sale or transfer of the business outright, or it can withhold its consent, effectively killing the transaction. It's not required to give the bottler any reason for doing so. What this bill does is seek to correct this imbalance by prohibiting a soft drink company from unreasonably withholding or delaying its approval to the sale of the bottler's business, provided that the proposed purchaser, bottler, meets the soft drink company's material and reasonable qualification requirements of its other bottlers. And this is not any new ground that we're plowing here today, as they say back home. It's not anything new, because this is language that we took exactly from the Bill of Wine Wholesalers legislation. And disputes as whether a soft drink company is unreasonably withheld its consent would be settled in circuit court, just like anything else where reasonably is used in the code. Then your course of action would be in the circuit court of the particular county or city where it occurred. And that's all it does. I think I have one witness here today to testify just briefly. Thank you, sir.
Please come forward.
Madam Chair, members of the committee, I'm Kevin McNally from Marston McNally. I represent the Pepsi-Cola Bottling Company of Norton, Virginia. This bill, as was ably described by Delegate Kilgore, really does not change the world. What it does is it makes that a soft drink bottler with enormous power over a family-owned business, a bottler's business, provide that bottler with good reason for not allowing that businessman to sell his business. If the proposed buyer meets all the reasonable qualifications that the soft drink manufacturer has for all of its bottlers, there is no good reason why that sale shouldn't go through. There are very many bad reasons why those sales are withheld or those consents are withheld, and I won't go into those here. But put it this way: when you cannot sell your business outright, and when the only way you can get consent is to sell to one person or to another hand-picked person, the value of your business, sometimes built over generations, rapidly diminishes. We don't look to impose a lot of regulations on the soft drink business itself. These are not operational restrictions. This merely has to do with the transfer of business among family members and to sell outright. I'd be happy to answer any questions. Thank you.
Thank you.
Is there anyone here in favor of the bill?
Hi, I'm Suzanne Brooks with Pepsi-Cola Bottling Company of Central Virginia. My grandfather started the business back in 1908, 115 years ago, and transferred it to my father, who was able to transfer it to my brother and me before he passed away in '84. Can you tell I'm nervous? Anyway, so we took that Pepsi business, which was pretty much the dregs of all the family businesses at the time, and have grown it over the years. We've taken time to grow that. We bought our Dr. Pepper franchise in the early 60s and grown that business over the years. And we want to just have a level playing field to be able to transfer our business to whomever, family member or to somebody else, and not devalue that business. If we can only get a piece of approval, then that would hurt us in the long run. So I just wanted to say, our family business, like I said, has been around here for 115 years, is definitely in support of it, and ask you to support it as well.
Okay, is there anyone in opposition to the bill?
Madam Chairwoman, members of the committee, my name is Jennifer Amundsen, and I'm the Director of Government Affairs for Keurig Dr. Pepper, a leading non-alcoholic beverage company that employs over 400 workers in Virginia. I'm here today in regards to House Bill 2486, a bill which, as you know, voids contractual provisions previously negotiated by private parties and applies new provisions retroactively through the legislative process. Keurig Dr. Pepper is one beverage company which contracts soft drink company which contracts with independent bottlers who are under complex private negotiated agreements between sophisticated commercial parties and are frequently represented by counsel in reaching those agreements. In the course of any contract negotiation, each party may negotiate to advance or protect their interests, and the resulting agreement is one of negotiated compromise. In many of these contracts, soft drink companies include contractual provisions that require the bottler to obtain consent from a soft drink company prior to any transfer of the bottler's business. These types of provisions are of critical importance to all companies that operate in exclusive bottling arrangements because soft drink companies rely very heavily on the capabilities and the expertise of the bottlers in their particular territories to successfully manufacture, distribute, or market their products. And in many cases, it's important to note that these contracts are long-term or perpetual. Additionally, we see it that as a public entity, a soft drink company has a duty to its shareholders to properly vet the bottlers with whom it is engaging to represent the company in the marketplace. That said, we take very seriously our relationships with independent bottlers and exercise any discretion only after very extensive and careful consideration. This bill would seek to impose a new reasonable standard in all contracts to govern a soft drink company's ability consent to the transfer of business. However, to note this, pursuant to Article 1, Section 11 of the Virginia Constitution, the Virginia Assembly cannot intercede in existing contracts, and this bill would be therefore ineffective in actually voiding already existing provisions of a contract. Further, we feel the broad and sweeping provisions of this bill represent a significant policy shift for the entire non-alcoholic beverage industry and beyond. It was noted that there may be some provisions related to transfer of business from beer and wine. Want to point out that alcohol is regulated by a state monopoly, the Virginia ABC, and the non-alcoholic beverage industry has no such regulator. There is currently no other state that imposes this type of regulation on non-alcoholic beverage industries. In order to fully understand the impacts of this legislation, we respectfully request
that this bill be referred to the Virginia Secretary of Commerce and Trade for study. A study would allow the Secretary of Commerce and Trade, as well as the relevant state agencies, to fully assess the economic impact of this policy and its effect on the Commonwealth and its businesses.
Thank you. Doug, ahead.
Yeah, real quick question for the patron.
Go ahead.
I don't see in this anything that would keep the parent company from exercising their right to turn anybody down. It's just that they would have to give a good reason
Right.
for
They
that.
would-
Is that, am I reading
Yeah,
that correctly
that's-
and understanding that? So it's not interfering with their contract. It's just asking them to clarify or causing them to give good reason why they would
And
be
not-
exercising
and
an
not
option.
And not unreasonably withholding its approval, unless, of course, they find that the person that they're selling it to does not meet their qualification requirements, bondability and things of that nature. So, yeah, they could, clearly, that would be something that you could get out, that would be very reasonable, in other words, yes.
Very good. Madam Chair, I have a motion at the appropriate time.
Okay. Delegate Lopez?
Mike's not.
Thank you, Madam Chair. Just a question for the patron. Would this, has the Virginia Beverage Association taken a position on this?
I think they're neutral on this. You got some small ones and some large, some small ones and some that are owned actually by the soft drink bottling company. So I think I think they're neutral on this one.
All right. Thank you.
Thank you.
Delegate Scott?
Thank you, Madam Chair. Question for the patron, and I guess as I listen to the testimony, so it sounds like to me, hypothetically speaking, Mr. Chair, Mr. Leader, if there were a buyer who wanted to, or that the owners wanted to transfer to a buyer, and they wanted to transfer it at $10, and the bottling company said, no, we'll take it for $1, they could do that based on the current law?
The way it's written right now, more than likely, yes.
Okay, as always, it's about the money. Thank you. Thank you all.
Thank you.
Thank you.
Delegate Head?
Move to report.
Second.
We have a motion to report the substitute for, well, there is no sub for this one. Okay, I'm sorry. Motion to report House Bill 2486. Is everyone ready to vote? The roll is closed. The bill reports 14-6. Okay, Delegate Kilgore, if you would, I'm going to stay here. If you would take over for
right.
the chair, I've one bill.
Delegate, Chairwoman Byron, you have House Bill 2198.
That's correct. Thank you. House Bill 2198, I have a substitute.
All right, do I have a motion to adopt the substitute? All right, I have a motion and a second. All those in favor of adopt the substitute, say aye. Opposed? All right. Chairwoman
Okay, this
Byron.
substitute comes from the Bureau of Insurance. As you know, we passed out a bill earlier that was explained to everyone dealing with the essential health benefit benchmark plan. And this is the bill that explains what we want the State Corporation Commission to put into the benchmark plan for the 2025 plan year. It takes that long to get this ready and to get approval and everything done. So this would include the things that were already agreed upon in the, I guess it was the last session, prosthetic devices and components that had to do with the formula and enteral nutrition products. This substitute makes it, they do the same in the Senate? Or haven't they done? Yeah, this bill, the substitute, it matches what is in the Senate now coming from HERC and coming from the Bureau of Insurance. The Bureau's here if you have any questions that have to do with the substitute,
All right.
because I'm just seeing it.
Does anyone have any questions on committee about the substitute? All right, anyone, this matches up with Senator Servell's that was approved by HERC.
Yes.
All right, anyone in the audience wish to be heard for or against House Bill 2198 as substituted? All right, committee operates on a motion.
Report.
Have a motion and a second to report. Cast your, has a sub. Cast your vote on your iPad.
And this is an emergency. Does that need to be up there too?
Emergency? Okay. Looks like you got emergency.
Good.
All right, clerk will close the roll. House Bill 2198 has substitute reports 21-0. Delegate Byram.
Thank you very much. That completes the docket for full committee, and we will take about a 15-minute break for sub 2. A little longer. How long? Well, we have to give a break anyway. All right. All right, sub 2 will start at 4:15. And then those of you that are waiting for those bills that are on sub 4, I think it's important for you to know that we will have, sub 2 will probably have to recess. Things are going to get backlogged. You know, this always happens the week before crossover. And Rules is meeting at 5, and several of us are on Rules. So we will recess for a while at 4:45. So if people want to grab a bite to eat between 5 and 6, that will help you out. Committee's adjourned.